there are part of comments coming through from the the FRCN's recommendations. They say that they considered the CBN Governor's response to some of those queries and some of their findings. And they also say that there was a clear display of incompetence, nonchalance, fraud, wastefulness, and abuse of due process, and deliberate efforts to misrepresent facts on the part of the leadership of the CBN. The Council then advised the President to exercise powers conferred on him by Section 11(2), subsection F of the CBN Act 2007, or invoke Section 11(2)(c) of the said Act, and calls the Governor and the Deputy Governors to cease from holding office in the CBN. Now, if you go to these sections which they talked about here, it tells us about procedure on how he is to be removed, where it talks about the 2/3 majority from the Senate, and the CBN Governor can cease to hold office if he is found guilty of misconduct. But that was a recommendation of the FRCN. But do you think those procedures from this recommendation were followed?
Well, I would like to throw light on that. If you observe the provisions of Section 36 of Section 5 of the Constitution of the Federal Republic of Nigeria, it says a person is presumed innocent until the contrary is proved. So we cannot sit here and be saying that the governor is guilty of those allegations. And if you check the provisions of Section 11 you just quoted, it actually talks about disqualification from office, and it uses that expression if there has been guilt established. So in this case, no guilt has been established.
Not even by the FRCN?
Not even by the FRCN. The guilt hasn't been established. It's just a mere allegation.
Okay.
It's just a mere allegation. And once the allegation, has been read out, the next thing that the FRC ought to do is to conduct an inquiry. After an inquiry has been conducted, if there's a prima facie case established, then it will be called to answer to the allegations, and it may have a valid case of presentation. So in this case, no guilt has been established. So the issue of cessation or disqualification of office or suspension does not arise.
Well, you seem to also, insinuate that he will have a case in court if he's challenging an alleged removal through the back door, so to speak, in the sense that he's been suspended and action has been put there, but also nominees have also been sent to the Senate, which effectively doesn't seem to give him any room for a return. But ideally, if all of the steps hadn't been taken, say, for instance, we're still like 2 years into his tenure where some people have justified these actions of the government, saying that he's not seeking a second term, and as such, by June next year or July, he ceases to be CBN governor, and as such, the government is only right in sending these nominees. But let's paint a scenario where, assuming this was happening, say, into the second year of his administration or of his tenure, and he was suspended, so to speak. Do you think that this would be right? Because some people will hold that there ought to be checks. There ought to be a way you can check the CBN governor if, for instance, there are infractions that are alleged to have been committed. He should be able to step aside from office for investigation, shouldn't he?
Well, I understand the position you're coming from. Well, that's, like I said, it's a principle of law that where there's a misbehavior or an investigation is supposed to be carried out on an allegation of crime, ordinarily speaking, the power of suspension can be exercised. The essence of this is for the victim, as it were in this case, to step aside so that an inquiry can be conducted. And once you are satisfied, you either, call him back into office, he continues, or, you take the necessary action. You see, but that has to do with the position of the law in that regard has to do with master-servant relationship. But you find out that the office of the CBN governor is clothed with statutory flavor, and the provision of the law is clear as to how it can be removed. That's the fear. That's the fear I'm exercising here, because the language of Section 8, 9, 10, and 11 of the CBN is very explicit as to the procedure for his removal. I believe the rationale behind that provision is to check the excesses of the president, so that the president may not just wake up in the morning one day if he looks at his CBN governor and doesn't like his face and just decide to suspend or remove him. The Senate has to be involved is a measure of checks and balances, based on the provisions of the law. But it is not to say that it is impossible for you to exercise a form of disciplinary, measure by letting the individual step aside. But in this case, like we rightly said ab initio, that it appears as though it's a removal because someone else is occupying that office, acting in that capacity as the CBN governor, and the name of some other person has been forwarded to the Senate, for recommendation. So those are the issues, those are the questions that will come before the court.
If we go with, pardon me for butting in, if we go with Marquez' comment wherein, look, the names that were submitted was because, look, he's not seeking the second term. He said he always knew he was going to have just one term. So if we assume that those names are for confirmation for this filling of that position for the next term, and then you come and look at the statement from Dr. Abati, where I think is the fourth and the fifth paragraph. In that fourth paragraph, I think the second line, where he now said that the president has asked Dr. Sarah Ladi, who will serve as acting governor, until the conclusion of ongoing investigations into breaches of enabling laws, due process, and mandate of the CBN. So do we then assume that he's asked to go on this suspension so that they can conclude the investigations? Because what do some people argue that, look, this is just outright removal, going by those corresponding events.
You see, like we say, we could continue to argue on and on this, but we have to leave it for the courts to decide if truly he's seeking, redress, in the court. That's the position I want to take on that.
Does it also tie the hands of the Senate? Would you see a situation where they will be able to consider the names of the nominees already sent to them when there is still, in quote, is it a suspended CBN governor whose powers are not clear, or, or an acting CBN governor and a suspended CBN governor? Do you think that they can actually go ahead and consider that?
Okay, as it stands today, Mr. Sanusi has only indicated that is seeking legal redress in court. So nothing stops the National Assembly from performing their statutory, duty to consider, that. If it now happens, he goes to court and the matter is in court, then the National Assembly can now take the initiative to wait for the procedure or the action in court, pending in court, in order for it to decide what next it will do.
But some people will argue that that doesn't affect, if it goes to court, it doesn't affect what they ordinarily would have done. Do you think it's too early in the day to consider, because he was going to go in June or July anyway? Yeah. Is it too early to start consideration for a new CBN governor?
Ordinarily, it's not too early because of the time frame. But I am looking at the legal implication. If he decides to challenge it, of course, we have to respect, the jurisdiction of the courts. If he goes to court, the prayers that he would take to court are what will matter, because he could ask for certain prayers, like maybe an injunction, an administrative, order that the National Assembly may want to respect, because the National Assembly also would not want to, interfere, with judicial process or do anything that will affect, the judicial process or adjudicatory process of the court.
Because therein he was talking about protecting the institution or the autonomy of the CBN, and that's why he thinks he should challenge it, so that whoever becomes the next CBN governor or the next president may be thinking of carrying out this same thing. So from what he's suggesting, it's a wrong precedent. Maybe that's why he wants to go to court and seek redress.
In fact, his suspension actually raises the question of the autonomy of the CBN in reality. It's beyond going to court, because the international organizations are watching. They are waiting to see, the outcome of the whole thing. And I want to believe that there will be so much pressure on Mr. President, today, because of that position the CBN governor occupies. My approach to that is this: we have to go back to the Banking Ordinance of 1952, the GDP report that led to the establishment of the CBN today. And the legislators have to reconsider the framework for the CBN, because as it stands today, the federal government does not really have so much powers. In fact, there's really little or nothing the federal government can do as regards the powers of the CBN, because there's an enabling law that defines what the CBN governor can do.
Well, and I was going to ask you about that, because even the president of the Federal Republic, he has checks and balances. I mean, the legislature can check him, the judiciary can check him, but the CBN governor, he's the chairman of the board. He determines what goes in, what comes out, and nobody can stop it.
This is why I had said that we need to go back to the CBN amendment bill presently, because the issues that are being considered by the legislators are not really the critical issues that they should be looking into. They ought to be looking at the issues of the power of legal tender, where it resides, and the powers, to borrow that is in the Constitution that the legislature has. So right now, the legislature only has power to borrow, and that's the power of the government. The government itself today cannot wake up one morning and say it wants to print money. It has to go back to the CBN governor. So even where there's a situation of distress or panic in the economy, it's only the CBN that can rescue, the economy, because the government's power is the power to borrow, and the power to borrow can only be exercised by the government in terms of creating bonds and debts. But the CBN has the power to issue currency notes, and the CBN can also issue treasury bills and issue other forms of security. So it's a form of combined, a hybrid power that the CBN possesses. So it's always very funny when the president is coming to interfere, with the affairs of the CBN. The international organizations will just merely be laughing, because the reason they are doing business with the government in any way is because, of the law that they know exists, the extant laws of the country that give the CBN that autonomy to do what it is doing. That's the power of legal tender and the power, to issue currency notes. And if you would observe this, you would note that the power to borrow that the legislature has is kind of restrictive, because as the government keeps exercising these powers, the nation keeps being indebted. Because the power to borrow essentially means the power to create debt. And if the government is borrowing, the government is merely creating more debt, and the nation is being soaked into more debt. But the CBN governor has the power to print notes, to issue currency notes, and the power to issue treasury bills as well. So he's combining both. So he becomes a fearsome and a very powerful individual.
Interesting. All right, as well, we have to let it go, unfortunately. Tilawa Oyefeso is a financial lawyer. Thank you for coming on this morning.
Thank you, Chamberlain.